We're going to talk about two topics: the status of Islamic law in the Indonesian legal system, and Islamic law and the national legal development of Indonesian law. Now, the Indonesian legal system is a legal system combined from several legal systems. The first is Western law system, which is European continental, derived from the Dutch. The second is customary law, which has already been around the community in Indonesia for a long time. And the last is the Islamic legal system. Now, customary law existed for a long time, but only gained recognition as a legal system in the early 20th century. To understand about Islamic law, we have to understand how the Islamic influence entered Indonesia and spread around the country.
The Islamic influence and rise of Islamic law in Indonesia. Islamic law has been used in the Indonesian archipelago since the arrival of the first Muslims who arrived and then settled down in Nusantara. According to the opinions gathered and summarized at the seminar Masuknya Islam ke Indonesia, which is translated to Seminar on the Arrival of Islam in Indonesia, that took place in Medan in 1963, Islam entered Nusantara around the 1st century of the Hijrah calendar, or the 7th or 8th century AD. Other opinions claim that Islam did not arrive in Nusantara until 13th century AD. The first region that came into contact with Islam was the northern coast of Sumatra. With the establishment of the first Islamic community in Pereulak in East Aceh and the first Islamic state in Nusantara, known as Samudra Pasai in North Aceh.
How did Islamic law develop in Indonesia? Well, one of the first traces of Islamic law is from the kingdom of Samudra Pasai. It's the first Islamic kingdom in Indonesia. It adopted the Shafi'i school of thought, and its influence was so large that Islam spread all over Nusantara, what is now known as Indonesia. Over that time, the Portuguese also tried to occupy and cause the downfall of Samudra Pasai. However, Islam has already spread all over Nusantara at this time, along the Malacca Strait, along Aceh, Minangkabau, Palembang, Jambi, Java, and even Makassar in the Kingdom of Goa. Around the 17th century, the Dutch East Indies arrived and gained control of Indonesia. They created some laws such as Statuta Batavia and other laws which contain Islamic marriage and inheritance laws. It also acknowledged Islamic scholars or penghulu to help settle legal disputes in court. After the Dutch East Indies, the Dutch government took over the area of Indonesia. Daendels was appointed as Governor General. Daendels created a decree that affirmed the status of penghulu as experts of Javanese indigenous law and religious law. Following the Dutch era was the British era. The British took control over most of what we know now as Indonesia. Raffles was appointed as Governor General of Java, and he reaffirmed and re-acknowledged that the law of indigenous population in Java was mostly Islamic law. After the British, in 1814, the British made an agreement, the Anglo-Dutch Treaty, with the Dutch, which they say that they will return Indonesia, or what will become of Indonesia, back to the Dutch. And during this time, the Dutch completely changed the structure of trade, agriculture, and even the judiciary system. So the goal of the Dutch was to make the indigenous population, the native people, to become loyal to the Dutch government. One of their idea is that if they can use religion, Christianity, and laws, if they could convert people to Christianity, they would become more loyal to the Dutch government, the Dutch king. And so efforts were made for Islamic religion, Islamic law, Islamic influence to be diminished. So the Dutch created a commission. The commission was tasked to adjust the local laws with Netherlands law, the Dutch law. This guy by the name of Sultan van Oud-Haarlem was tasked to do so. However, he held the opinion that to prevent friction, the Dutch must allow existing religious law and customs and even traditions. And so nothing was changed. The Dutch still officially acknowledged the existence of religious law, the Islamic law. In 1882, the Dutch officially recognized Islamic law, in which they created a religious court. It was created in Java and Madura, which reviewed cases of inheritance, divorce, and a lot of other issues related with Islamic law. After this, there was some kind of debate between two prominent figures, Lodewijk William Christian, or LWC, and Christian Snoek. Now, LWC was a Dutch legal expert. He conducted a lot of research, and in 1884, he wrote principles of Islamic law, including according to the Hanafi school of thought and the Shafi'i school of thought. And he encouraged judges in Indonesia to apply Islamic law with the assistance of the penghulu. He found that Islamic law governed Muslims in Indonesia. He argued that Muslims in Indonesia accepted Islamic law as a whole and in its entirety, in totality. This theory became known as receptio in complexu. Now, Snoek, he was an advisor to the Netherlands, and he advised on matters relating to Islam and indigenous community. He rejected the theory of receptio in complexu. He argued that the prevailing law for Muslims in Aceh and Gayo was not actually Islamic law, but traditional customary law. He stated that Islamic law only applied when its elements are incorporated and accepted as part of traditional law. This theory was known as the reception theory. Now, numerous scholars rejected the theory, Islamic scholars, law scholars. The theory was viewed as a way to diminish the Islamic influence in Indonesia and to strengthen Dutch's rule on the indigenous population, which was the majority was in Muslim, in which the majority was Muslims. So in 1922, the Dutch commissioned to review the authority of the religious courts, the one that was previously created in Java and Madura in 1882. Influenced by the reception theory by Snoek, the recommendation was to revoke the authority of the religious court. In 1937, a law was passed which revoked the authority of the religious court. Now, matters of inheritance law are now under the jurisdiction of district courts. Now, numerous protests began to show up. However, a very famous case highlighted this problem. This was a district court case in Bandung regarding inheritance, which actually should have been in a religious court because the plaintiffs were Muslim. The adopted child claimed that he should receive all of the inheritance, and the court accepted this. By doing this, the court completely ignored the biological inheritance line for the nephew and nieces. And this ruling was protested by many Muslims, especially Islamic organizations. They view this as violating Islamic law. They view that this forced a Muslim to follow a non-Muslim inheritance law and is viewed as violating their religious belief. So there was a lot of protests, there was a lot of cries to stop the implementation of this law. However, the Dutch just completely ignored them. Over the years, the Muslims created efforts to try to reinstate Islamic law back into the legal system. And they finally had a chance when this was during the Japanese occupation era, where the Japanese created an Independence Preparation Assembly, otherwise known as BPUPK. And among others, this assembly was to conduct research on, legal laws, constitution, what type of state Indonesia wanted to be, and Islamic leaders tried to put Islamic law at the forefront of the Indonesian legal system. These efforts eventually led to something known as the Jakarta Charter, or Piagam Jakarta. During the drafting and formulation of the Indonesian Constitution, this Jakarta Charter was created, and in the charter, it states that the preamble of the Constitution is to specify that Muslims are required to abide or carry out Muslim law. In the end, the founding fathers, in 18 August, which is actually one day after the independence, replace the wording of the Piagam Jakarta to simply just state Ketuhanan Yang Maha Esa. Why is this? It's because the founding father believed that religion and state should not be combined. It should be separated. Yet they created a compromise because of the very powerful influence of the Islamic community at that time, which wanted to emphasize their beliefs. So the founding fathers added the words Ketuhanan Yang Maha Esa, which means the one and only God, which is to emphasize that although Indonesia is not a religious state, however, it is based on a belief of a supreme being. And this was the compromise made by the founding fathers